Okay, good afternoon. Thank you very much for being here. I am the chair of this panel. I represent CEDPO. CEDPO is the acronym for the Confederation of the European Data Protection Organizations, and in particular, I am the Spanish representative in the sense that the Confederation is formed by various European data protection organizations, and therefore I have the two roles of the CEDPO representative and the Spanish one. In addition to this role, I am an external lawyer. Therefore, my profile also is to try to help the DPOs not only from the side of an association which tries to provide guidance with respect to the training, with respect to how we get or we raise awareness with respect to the task that the DPO may have in the organizations, but also the price. Sometimes I say that I have become a data protection practitioner by accident. And I think that this is something that I am not a rare example. I think most of us have different backgrounds, and we have become DPOs or close to the DPO function for certain reasons that are not because we have a university degree on DPO. And it has caused a certain number of questions with respect to the kind of tasks and roles that we are playing already and that we would like or we will be forced to play when the European regulation, if ever, will be finally approved. And this is not only a question of Europe. We have had, I think, a certain number of concerns with respect to other regions in which we Europeans claim that others do not have any kind of privacy. And it seems that the chief privacy officer or the kind of DPO role have not really started in Europe, or at least not in all the European member states. And the United States is actually one of these countries in which the chief privacy officer has a role and an important role within the organizations. I have the pleasure to have in this panel different profiles of different approaches that we may have with respect to the role of the DPO, both from the private and the public sector. I will first do it as an external practitioner by the public in order to present Delphine Harou from the EDPS, which I think will be able to provide a perspective from the policy perspective. Philippe Renaudière, who is a very experienced DPO in the European Commission, so not only in the public sector, but the one which is deciding many of the policies and then the DPOs of the private sector will need to follow. And then we have the private sector also represented from both the US and the European side. Jennifer Barrett-Glasgow here in my left, she is the Global Privacy and Public Policy Executive from the US, so a very big task and very important role within a global organization, not only in the US, in Europe, but also in Asia. So different regions in which not necessarily the task of the DPO are the same or the expectations that the authorities, the users, and even the organization may have. Gabriela Krader, she is one of the European representatives of the private sector in the Deutsche Post, and she is a DPO also in a global organization, but more European-sided with respect to the headquarters, and she's also dealing with global decisions within a big organization. And with respect to a legislation in the origin, which is reputed, as well as the Spanish one, to be one of the strictest in Europe. And therefore, I think this also helps to have a different approach than others that we may have. And Leticia López-Lapuente, she is from Spain, so we have the pleasure to know each other from the external practice at the very beginning, but she moved to the private sector, to one of the biggest insurance companies and multinationals in Spain, which is Sanitas, and which belongs to the Bupa group, that maybe is the name that you may know much better in other regions. She is in charge of the data protection functions, among other compliance tasks, not only for Spain, but for this big multinational, which has also many interests in Latin America, which has certain of these countries, and most of them had adopted a European-sided or Spanish-sided, depending on how you look like, data protection landscape. With this panelist, I will leave the room to our moderator, Stewart Dresner, that I think most of you know even more. I don't know if he was practitioner by accident, but definitely he was in this world even before most of us started in this world. So that I will leave him the, the floor in order that he present much better himself, and that we may start with the question that I would like that all the panelists may approach. Thank you.
Thank you. Thank you so much, Cecilia. Yes, I'm Stewart Dresner from Privacy Laws and Business. Yes, I said the reason I'm here, I'm sure, is because I've got very long experience. Could you go on to the next slide, please? We started publishing this, we used to call it a newsletter, now reports, in 1987, where there were about 10 countries with national laws. And now in our survey we're publishing next month, our 28th birthday month, we're a survey of 109 countries in the world with privacy laws. So this publication comes out 6 times a year, paper and electronic formats, and with free email updates. And we're happy to give you a free sample copy at the end of this session. Moving on to the next slide, this is our world's longest running privacy conference, except for the Commissioner's own conference. It's in St John's College, Cambridge, where if you've seen the film The Theory of Everything about Professor Stephen Hawking, this was shot, much of the scenes were shot at St John's College, Cambridge. It's an attractive place, and all the more information on our website. Well, that's enough about me and my organisation. Let's get on to the presentations by the panel members here. And we're going to start off with Jennifer, who's from Acxiom. She has the role of Chief Privacy Officer, Global Chief Privacy Officer. So would you take over and explain first? Each of the speakers are going to first of all explain about their organisation, and then how the data protection function is organised, all in 2 slides each. So that's easy, isn't it?
Thank you, Stewart. I'm delighted to be here and appreciate the opportunity to talk to you in this, on this topic. First, let me tell you a little bit about the company I work for, and then I'll tell you a little bit about my role there and the privacy team. We're not a well-known household name, but we have operations on almost every continent. We have facilities in about a dozen countries, and that's growing. Across Europe, across Asia, and as well as in Latin America. And of course, our headquarters are in the US. We offer a number of services, but the majority of our revenue comes from the first 2 that are listed here. The first one is we host data for our clients, primarily customer data that they have. We help them organize it, clean it up, and then we offer analytical services to help them understand what they can do with it. And this is typically done, although it does vary from region to region a little bit. Most of those analytical services are directed around marketing activities, but we also have some risk-based analytics that we do in the US. We also help our clients engage with data in the digital space by getting their information, their offline information, onto the digital world so that they can use it, whether it's in the internet, whether it's in the mobile space, or most recently in interactive and addressable TV. So we're speaking about, with our clients and in the marketplace, we are addressing pretty much every digital data issue that comes down the path. We have a small line of data products where we collect data from various and sundry permitted and public sources that we then sell to our clients to augment the information they have about their customers. Again, both for risk management purposes as well as for marketing purposes. And these products obviously vary greatly from region to region based on the laws and various customs in each country. While we have offices in 12 countries, we process data from 40 different countries around these regions. So we're very familiar with all the differences in the laws and the cultural regulations. Now, the privacy team, I had the pleasure of starting the privacy team shortly after Stewart started his publications in 1991. And over that span of time, it has grown substantially, as the business has grown as well. But I'm responsible on a global basis for all of this. I report to the General Counsel and our organization, but I also have kind of a dotted line into the Board of Directors as I give them a report annually and on request whenever some issue surfaces that they'd like to know about what our program is and how we think we're doing on it. I have about 20 individuals on the team. They include some lawyers, they include some people focused on compliance, they include people who have actually am not a lawyer. I happen to have a degree in technology, so we have some people on the team whose background is more technical oriented, and that's becoming more and more critical as we move into this age of digital everything. And then obviously some administrative help. But we think about privacy in what we call a 360-degree approach. And our team has some responsibilities that may not be typical of a privacy officer. Obviously, legal compliance is kind of the starting point for everything we do. We also are very active in industry self-regulation, and as you know, in the U.S. and in certain Asian countries, we don't have comprehensive laws like we have in Europe. So we supplement those with self-regulatory activities. We establish the policies for the company in order to comply with the law, and then we train the employees on how to do that. We also review and consult with all of our product and solution people doing privacy impact assessments on the activities that they're involved in. And just for the record, in the U.S. we did over 800 privacy impact assessments last year. We also have a compliance and assurance role to play in that we audit the lines of business that have to follow these policies to make sure that they are actually doing what they're supposed to be doing. We handle all of the consumer interfaces for subject access requests, for opt-ins or opt-outs and that activity. And we consult with clients who want often to know as they move into a new region of the world, you know, what they can expect or what the issues are that they should be involved in. We also deal with the media because these issues can get very controversial and sometimes very timely from a media perspective. And then the thing that I think probably is not as common from a privacy perspective is I also manage our government relations activities, in that most of those activities are about data. Occasionally we have an employment issue or a tax issue or something else, but by far in excess of 95% of our government relations issues are with data. So it fell to our organization to handle that. So I look forward to the rest of the panel and answering questions that Philippe's going to challenge us with. Stewart's going to challenge us with, sorry.
Well, thanks very much for that overview. I'll just ask you one or two points now before we move on. I see that you address all the main classic roles of Chief Privacy Officer involving training, privacy impact assessments. Impressive number of 800 last year in the States alone. Do you do them in other countries as
Yes,
well?
yes.
That's good. And you offer audits, media relations. So you have to be quite a polymath, a sort of lady for all seasons to cope with this responsibility. Now you've got offices in 12 countries. Approximately how many of those countries have privacy laws you need to be thinking about?
All but one.
All right. And then you have to decide how to apply the company policies in those countries with laws and the one without.
Exactly.
Could you reveal which one it is that does not?
Brazil is the one right now that is moving down the path of establishing a privacy law, but does not have it. And so our approach to how we, and I know we'll get into this more with the questions, but our approach to how we develop policies is we have a set of principles that are our global principles that we have harmonized with all the various laws that exist, at least today. And they're pretty much what you would expect. They sound much like OECD principles or other global privacy principles. And then we have implementation and policies related to each country. Because we're such a data-intensive company, we want to be sure that we are maximizing our clients' use of data. And so, you know, for example, in a country where we collect email addresses in the U.S. or in some Asian countries, that is done under an opt-out standard, and of course in Europe it's an opt-in standard. So that would be an example of we have a notice and choice principle, and then we would implement it slightly differently in different regions.
Okay, thanks very much for that overview. And we heard this conference yesterday that, as you said, Brazil is moving towards the law. Let's move on to our next panelist. Thank you. And I think Delphine is next. Delphine Harou. You are the European Data Protection Supervisor's Office. And tell us about your organisation and role. Quite different indeed from Acxiom.
Yes, very different. And Cecilia, it's from the supervision point of view and not from the policy point of view, so I hope I won't disappoint the audience. So the DPS is the Data Protection Authority for the 62 European Union institutions and bodies. And compared to a classic DPA, our context is a bit specific, as the number of the entities we supervise is limited. So it's like a laboratory. So we monitor processing operation of two kinds: the processing related to the administration of public bodies, typically management of employees, recruitment, evaluation of staff, etc., and processing related to their core business activities. For example, asset freezing measures against persons suspected of financing terrorism. We use different tools to monitor the application of data protection principles. We conduct prior checking, inspections, compliance and consultancy visits. We reply to consultations, we handle complaints, and we provide guidance in the form of thematic guidelines. Each activity is carried out in close cooperation with the relevant DPO, who has the underground knowledge. And having a DPO is a legal obligation for the EU institutions since 2001. The role of the DPO and his status are enshrined in Regulation 45/2001. The EU DPOs are organized in a network that meet twice a year with the EDPS, and we've analyzed their role through a survey that we conducted 2 years ago. Now, the data protection officer at the EDPS, again, his role is a bit specific. The EDPS team is composed of a DPO from our IT policy team and an assistant DPO from our policy and consultation team. As a rule, the DPO cannot be a member of the supervision and enforcement team or have responsibilities in human resources. And as I said, the context is a bit different because, of course, the DPO in the EDPS do not need to raise awareness about data protection principles. The DPO team works in close cooperation with the supervision unit, which has a lot of experience in the field, and the human resources unit. The DPO team reports to the director regularly, and we have an internal decision which describes the status, tasks, duties, and powers of the DPO and the rules governing the exercise of rights by data subject. And finally, the EDPS as an institution has already started to implement the accountability principle. And of course, our DPO is a key player in this process.
Okay, thank you. A very concise explanation there. My question for you is, do you do this full-time, this role, or do you do other tasks within the organization?
No, we are the supervision and enforcement team. We are 12, I would say. It's a full-time job. We do conduct this prior analysis of every sensitive or risky processing operation. We reply to the consultation the DPOs may have, or the controller may have. We do handle complaints. It's our full-time job. Yeah.
Right. Okay. And do you, when you conduct an audit, is that in response to a problem, or do you have a systematic program which you run anyway?
Yeah, we have both. So it can be because we notice that there is in fact a problem of compliance, or it can be what we call that inspection and not audit. And for instance, we can pick up a specific topic like video surveillance and the information provided to data subject, and then we will check a series of institutions in Brussels or in Luxembourg and check all each time the same thing.
Right. Okay. Thank you. I think it would be better really to go on to Philippe Renaudière next. Yeah. Although that's not quite the order we got the slides. Because we just move on the slides too, because the two sort of roles relate together. We'll come back. Right. Yes, I introduced Philippe Renaudière because he's also working regarding the European institutions. And we discussed earlier the fact that he's been involved in the European Commission for as long as I've been running privacy laws and business. So we have this in common. And he also had the distinction of having been responsible for the distinction for being the policy on the data protection directive, the current EU directive. And now he has the enviable task of involving implementation in the European Commission. So, Philippe Renaudière.
Yes, thank you, Stewart. Thank you for this very challenging introduction. But it's true, I've been in the data protection business for 13 years now, 5 years as the head of the data protection unit, so doing policy and legislation, and since 8 years now, data protection officer in charge of internal compliance. So as Delphine explained, we are working on the basis of a specific regulation, which is Regulation 45/2001, which regulates the processing of personal data in EU institutions. It's a very close copy of the directive, but with some specificities and with this important difference that it is a regulation, so it is directly applicable without margin of maneuver for national interpretation or national implementation. Now, the Commission, I suppose most of you have heard about the European Commission. It's a quite large organization with 30,000 people, organized in a very decentralized way in departments, services, task force, departments, directorate generals, directorates, units, you name it. We have identified 900 more than 900 processing operations on personal data, so systems, databases, administrative procedures which collect or process or store personal data. And we have a series of a very wide diversity of processing operations. Of course, HR activities are an important part of them, but so selection, recruitment, career development, and well, disciplinary procedures of our staff. We are also our own medical insurance service, so we process a series of health-related data, pension, social security, but also we interact largely with the public, so we have mailing list, we organize meetings, we organize events, and of course we have a series of people who come in contact with the Commission because they are interested in a project, in receiving grants, subsidies, participating in financing operations, and of course auditing and conducting ex post controls of all these activities. So it's very wide. Now, how does it work? Well, the function of DPO, as mentioned by Delphine, is described in the regulation, the tasks, the duties, the responsibilities, the powers. It is important to note that in the regulation itself, it is specified that the DPO enjoys a full independence, which of course is of a great help and support for our daily work. The Commission decided to have a very light structure in terms of organizing the DPO function. There is basically one DPO, your humble servant, with 2 assistants, and then a network of correspondents in each Directorate General, network of a bit less than 40 people. The DPO is administratively attached to the Secretariat General, so to the Secretary General, so the highest civil servant in the organization, with direct access to all levels of decisions and of the organization, which is also an important point. The tasks are, as said in the regulation, to ensure in an independent manner the implementation of the provisions of the regulation. So it's assisting, advising, informing data subjects and data controllers of their rights and obligations, receiving and investigating complaints, cooperating with the data protection supervisor, the European data protection supervisor, either in an ex ante way, because we are obliged to notify the most sensitive processing operations to the EDPS for prior checking, but also ex post in case of inspections. And I can tell you that it's true, it's happening, and it will, as far as we are concerned, it will happen next week again. We already had the visit of the EDPS inspectors in our medical department, in our recruitment and selection office. So these are very serious inspections, or on-the-spot controls on the basis of complaints. So it's a quite active position. And I think I can stop here and wait for your questions.
My one question to you is, do you receive more complaints from within the European institutions or more complaints from the public who deal with the institutions?
Well, it's difficult to have statistics because on the whole the number of complaints is very limited. It's less than, well, it's around about 10 per year.
Oh,
I would say that the majority comes from inside, but not exclusively.
Okay.
Sometimes members of the public have a problem with the processing of their data by the Commission, and they make a complaint, either to me or to the EDPS, or to both at the same time.
Okay, thank you very much. And so that was a public sector Euro part of the sandwich with the private sector on one side, and now we turn to the other private sector examples we have here. So whose slides will come up first? Gabriela Krader, okay, from Deutsche Post DHL. Oh, sorry, yeah, sorry.
Thank you very much. Thank you, Cecilia and Stewart, for the invitation. Deutsche Post DHL is a not so small, I have to say, postal and logistics service provider. We have around about 480,000 employees and are present in around 220 countries globally. The whole group consists of about 1,000 legal entities, so that doesn't make the job any easier, I can tell you. Regards the services we provide, despite the classical postal and logistics services, we also have on board dialogue marketing services, so it's very similar to what Jennifer just referred to. And also we provide outsourcing solutions, which includes certain kinds of digitalization services, as we call them. Simply, this is like certain printing services and this kind of stuff, which perfectly combines, of course, with postal and mail delivery services. We also provide secure electronic mail, our e-post service, and try to be very progressive in the development of high data protection standards for email communication services. A very new branch, but still increasing branch, is e-facilitation and e-payment services. So also the e-commerce sector is very interesting for our group. You can imagine that given that scope of services, we do not only face a very different data protection and privacy regulation in this world, but we are also subject to sector-specific regulation, partly in the financial services, but obviously in the core of the postal services and postal secrecy. So handling personal data with care is definitely integrated in the services of the company, and many people are involved in taking care in that respect. Perhaps we change to the next slide. So because the requirement was 2 slides, this slide is a little squeezed. I apologize for that, but a short look on the organization in Germany. I also report to our Global Legal Council. I work with a team of 21 members, which covers, so to say, 2 fields. One is the group privacy coordination with overall policy competences, guideline competences, and everything which comes down to questions of principles and processes. And we also cover the operational data protection management in Germany, which means anything related to that, like trainings, audits, customer complaints, or complaints of individuals overall. Here you can see some of the locations you can find my department members in Germany, but the core department is located at the headquarters in Bonn. We work together with a group of data protection coordinators, which do not belong to my organization, but are on, as we say, the implementation side, the business side. These are in Germany, around about 100 people, but these people are not full-time employees. So it depends, it ranges from, let's say, 50% or sometimes 20%. They are located in the business branches, and they are our main interfaces in trying to do research, clarifying complaints, and so on. On the international side, we have at this time we have 18 formally appointed DPOs, particularly in Asia. It's remarkable if you have a look at the fast developments there. And overall, we have built up what we call a data privacy network. This is a network of all people being involved in data protection and privacy consultancy in the group. Members to this network are primarily our local legal counsels who deal with data protection and privacy issues according to the relevant legislations. And the numbers you see here is just more or less the starting numbers. We are still in the process of increasing this data privacy network. Last but not least, I have to say that in the international area, not all of the DPOs or privacy network members you see here work as full-time employees in that area. Some of them also have other tasks too.
Thank you. That's very clear. So in addition to understanding the subject, you also have to be a manager of people, because you've got people directly in your department, then a very large number of people around the world you have to look after with a dotted line rather than formal responsibilities. So that's juggling many responsibilities. So that's a very difficult task to do. Now, when you said the company is going to e-commerce and e-payments, are the e-payments similar to PayPal, that kind of thing? Mm-hmm. Yeah, that sort of thing. But a sort of a European version. So.
Yes, I would say so. I would say a German version. Sorry. Technique. A German version for the time being, but on the way for expansion, and I think it could one day it could be a global service as well. So yeah.
Okay, so lots of issues there.
Yeah.
Indeed. Okay, so we'll now pass on. Thank you. So I'll hand the microphone to Leticia López-Lapuente, who's Chief of Privacy Officer for Sanitas, which, as you were saying, is a subsidiary of Bupa to do with health care. So lots of sensitive data.
Sanitas is the brand, the commercial name that the Bupa Group uses in Spain. It's a group of companies that is very well established in Spain. It has been operating in the insurance and health services sector for more than 50 years. I just give you in this first slide some figures just for you to know the amount of data that we deal with, but it's not a matter of a number or of a figure. It's a matter of, in my opinion, of the high sensitivity of the data we're dealing with every day. We are there. We are a partner, a health partner for our customers. We are there when they are giving birth their kids, and we're also there when they get old with more than 40 care homes all over Spain. So we go together with our customers throughout their lives and managing something that we know that is crucial for them, which is the health-related data of personal data, but also of their families, minors, kids, and so on. So as you may well understand, processing of personal data is a core matter for Sanitas organization and for the Bupa Group. Just for you to know the businesses we operate, the core and the origin of this group was the private medical insurance, but it has expanded in the last decades to others health-related services. We manage and we have hospital and day clinics and care homes and dental clinics and aesthetic services, and we are very active also in the online health-related application apps and services, which which is the future, those health-related wearables, and we're also very active in the IT-related matters that deal with health. And because we're not operating only in Spain, well, the BUPA group operates in almost 200 countries, but depending directly from Sanitas is the expansion of the BUPA group in Latin America. So, for example, last year we did a big acquisition of a listed company in Chile, which has also private medical insurance and a lot of clinics all over Chile and Peru. And so we deal not only with the Spanish matters and also with those in Latin America. And we also have to coordinate our data processing with the BUPA group, which is mainly based in the UK, but has operation in almost 200 countries all over the world. And going just more in depth into the data processing organization, the main function is led by the legal department, in which I operate I'm part of the legal department, but we also have a lot of coordination with the IT security team. Just for you to know, in Spain we have not only the obligation to have to comply with and implement the mandatory security measures, but we have a specific list of mandatory security measures that we need to comply with. So every time we buy a new IT tool, or we have we need to check that all the list of the mandatory security measures that are mandatory according to Spanish law are complied with. So IT security team is part of our daily work. We also work with the claims department because we have a lot of our customers exercise their rights of access, cancellation, and objection and rectification, and we deal with 100 of these right of access requests every month. And also there is this information governance group, because we cannot care only about data protection laws. We deal with health-related data, which has some other regulations that are applicable to this data. For example, those regarding clinic records. So we have to make a very comprehensive approach to the data, not only taking into account data protection, but many other regulations also.
Okay, thank you. Well, that's fast developing. You're dealing with sensitive data, dealing with online health services, apps, IT, wearable tech. Fantastic. What a responsibility. Many countries, at least several continents. What a responsibility. So this gives us, across all the panel members, we have all different types of experience of the role of the Private Data Protection Officer. And in fact, I think we should pay tribute to CEDPO for constructing this incredible comparative survey, which you can find if you put into CEDPO survey of role of data protection officer, which has looked across about 12 or 13, oh, you've got it there, 12 or 13 countries. Of course you can't read it, but it looks across the way the law, the national laws, have dealt with responsibilities of the data protection officer in each current national law, and a very interesting similarities and differences, far too detailed to go into now. But you can say, Cecilia, that you did the Spanish section.
Well, some of the people who are attending, actually, the venue has contributed to this chart, which was one of the first works that CEDPO carried out at the time of its foundation in 2011, when we were thinking that the draft of the regulation was about to be approved just immediately. And therefore, we were a bit we were in the urgency of studying the landscape of the DPO status in order to make comments with respect to the kind of definitory role that the draft of the regulation had with respect to the DPO. And we have not the surprise, but I would say that this lack of homogeneous landscape that it is in many other data protection obligations or rules or characteristics, this is also the case for the DPOs. We have DPOs that are mandatory, others not. And even when they are regulated, there are differences between how you manage in order to ensure the independence, the liability of this DPO. When the first time in Spain you are promoted to be a DPO, it is never a good news, because you see all the burden of the liability of all the tasks that you are going to do and very little help. And CEDPO was also created in order to provide this kind of help to the DPOs, because they are facing a certain number of liabilities vis-a-vis the business decision within the organization, which are not easy. It is not only a question of data protection, many times, as Leticia pointed out. There are many other laws that are also intervening, and many other decisions from a business point of view that should also be taken into account. So it is not only privacy-centric thing, but it is a privacy-important thing that we need to have in our hands.
Thank you, yes. And I think the survey covers about 10 or 12 countries now. Yes. So absolutely incredible sort. It kept me entertained. My Eurostar train was delayed by 1 hour. There's no problem. It kept me entertained for 3 hours, I think, this survey. Very, very interesting. Right, let's take some questions from the audience. We have some other questions for the panel, but we'd like to give the audience, I'm sure there's some data protection officers here. Maybe it's your opportunity to spend a few minutes asking some questions to the panel now, because if not, I'll ask more questions. And I think this is your opportunity. Right, gentleman over there. We have a microphone here, please. How many other people would like to make a point? 2 people here? Okay, so let's send the microphone over here. The microphone is coming, so please give your name and organization. Thank you.
Good afternoon, everyone. My name is Elias, and I'm a data privacy officer for Health Market Science based in the US. It was very interesting hearing your introductions and looking at how you go about your roles. And one thing that stood out for me was Jennifer's role. And you look at the different components that go into it, whether it's media relations, government relations, and all these different parts. And I wanted to get a sense, at least from the European side of things, and how you view the DPO role. And to what extent do you think having all those different components is compatible to the views of the regulation, and really the expectation that the regulation has in what role the DPO plays in data privacy?
So may I summarize? Just keep the microphone for a moment, because you've got some, but no, you keep it for the moment. So may I summarize your question? I want to know, does the requirement in the draft regulation properly reflect current experience? Was that a reasonable summary? Yeah. Okay, let's go to Gabriela Krader first.
Well, I understood your question slightly different in saying whether the regulated data protection officer also allows for functionalities mentioned by Jennifer, which are, I think, absolutely key for the position, like communication, perhaps even, say, lobbying, this kind of stuff. Yes, I would say it does. There is absolutely no prohibition. Of course, it very much depends on the specific situation of your company. And to also engage in these important areas, it's absolutely necessary that you really have an organization with you and not just being a standalone data protection officer. And of course, particularly in the small or medium-sized enterprises, you would more find part-time data protection officers or standalone data protection officers who obviously have more difficulties to engage in that. But for the group companies, it's, I think, absolutely important to cover all these issues, because there it's not only a question of compliance, it's a question of management. So you have to cover all these interfaces, you have to have the skills, what Jennifer mentioned, you have to have legal skills, technical skills, communication skills, and because this obviously cannot be done by simply one person, you need to have a department with all these skills, and then you have to engage in that, because this really contributes then to the business success also of your group. So there is absolutely no contradiction, but you have to see it as an enhanced role, which is important in some cases, depending on the size and the scope of your business, and it's not, you can't find it everywhere. So it very much depends on your business, but yeah, it's there, yeah.
Yeah, just commenting on Stuart's approach to your question regarding whether the European draft regulation correctly covers or not the functions that we're all carrying out currently. If you see the regulation, it talks about coordination, monitoring. So it seems like the DPO doesn't have to do the task directly, but only to monitor and coordinate that they are done within the company, which is realistic in many cases because they deal with IT matters and business matters. But at the end of the day, I think that the draft regulation also talks about something that is key for data protection officers, which is the privacy by design principle, which means that DPOs need to get involved in all designs of services, products, but not only of that, but also procedures within the company, contracting procedures and communication with clients. So the privacy by design principle is in the draft regulation, and I think it's key, it's a basic for all our tasks.
Yeah, so you have to really be good at many different functions, and the law can't give you a precise job description, but I think across the panel, different members, you've seen many different roles. Did you want to say something?
Just something very quick. There is something else in the regulation which goes also in line with the capacities that the DPOs need, which is the direct report to the management of the company. It is impossible that you have a role of this importance and with the consequences that you have in the decision-making process within an organization if you are not close to the top of the company. And this is something that has been included also in the draft of the regulation. We have comments from CEDPO in the way it has been drafted, but the idea which is behind it is not only one person alone in a room saying that because there is a privacy rule, nothing can be done in a company. It is much more complex. And the only way in which you are able to have an impact in the decision-making process is if you have power and if you have resources. And for this, you need to be close to the management.
Okay, thank you. Yes, I can. Well, okay, we'll make one point. Yes.
No, on that point, and perhaps to underline the specificity of the EU approach, initially, if you go back to the 95 directive, the function of data protection officer is presented as an alternative to notification. So it's a way to derogate or to exempt an organization from the duty to notify each and every processing operation to a supervisory authority. So it's a sort of self-certification. You have somebody inside the organization who keeps a register, an inventory, and ensure that what is done in the organization complies with the rules, and then you have only to notify the most sensitive, the most risky operations to the supervisory authority. And as far as I'm concerned, this approach has really dominated the first years of my mandate, i.e. establishing a comprehensive inventory of the processing operations on personal data. So who in the organization is processing personal data, for what purpose, under which conditions, and then checking the compliance of all those processing operations, notify what needs to be notified to the supervisory authority. And this is a quite long and cumbersome process, but on the other hand, it allows the organization to organize itself without a constant interference of an external supervisor. This part of the task being completed, I think the second part of the task of a data protection officer is information, awareness raising, training, internal communication, which is largely underway. And then the next step would be, as you said, to be involved in the decision-making process at an earlier stage. And the new regulation will certainly help us by putting the emphasis on privacy by design, privacy impact assessment, privacy by default, where the data protection officer will have to intervene.
Okay,
Sorry.
thank you. Yes. So the role, I think, the data protection officer has to keep up with what is happening in the company, because it's the sort of front line, the risk assessment, and then following up with audits and so on. So that question was very good. A lot of good responses. Now, lady next to you, you had a question as well. So let's have your name and organisation, please.
Okay. Good afternoon, everybody. My name is Sheila Muchilwa. I work for Euroclear Bank. I am DPO for all the Belgian entities and Deputy CDPO for all our other entities. My question is addressed to both DHL, Sanitas, and yourselves on the aspect of international transfers. How have you been able to tackle this issue? Because it's not that easy. I know we are challenging safe harbor. Sometimes we opt for model contracts, but the annoying thing is you need to renew them. What is the approach you're currently using?
So we are specifically to Jennifer and Leticia, yeah, I think, yes.
Yeah. And sorry, and I have a second question as well, so, okay.
Okay, I can answer quickly. We were one of the early Safe Harbor certified companies, and so, but because most of the data we're transferring is not Acxiom data, it's our client data that we're processing in a different location. We also sometimes use model contracts at the request of the client, or because certain institutions are not covered under Safe Harbor, like the financial services sector, which in the U.S. is not part of the Safe Harbor program. And we participate in the APAC cross-border privacy program when it comes to Europe. So we're hopeful that over time, but BCRs and Safe Harbor and APAC cross-border privacy programs will at least recognize some mutual overlap and commonalities, so that we're not managing all these different regimes for all these different data transfers, because quite frankly, data at some point in time may go almost anywhere within the company.
Okay,
Thank
so
you.
will you be adopting APEX program for Japan when it comes on board?
Yes, we will.
Oh, right, thank you. Okay, so what about how do you organise your international transfers?
Since we are a European-based group, and we have, after many data sharing projects where we are sharing IT tools among the whole group, we came, at the end we find out that the more strict regulation is the European one. So at the end of the day, we try to the most easy way to deal with these international projects is to look for a European-based IT provider. This is the truth, because otherwise we will be dealing with a lot of model clauses. So sometimes it is a more expensive solution, but from a regulatory point of view, it will be easier for us. Especially taking into account that countries like Spain, we are not fine just with signing model clauses. We need to go to the Spanish Data Protection Authority, and we need to request a prior authorization, which is a long process. It is not an impossible thing to do, but it takes a lot of time, a lot of documentation, it costs money, and so at the end of the day, the easiest way is to look for an IT provider that is able to ensure that they are European based, that any accesses will be just limited to safe harbor companies. It is not a good solution, because it really restricts the ability of companies in looking for the best IT provider. But we are aware that there are so many regulatory restrictions that we take this easy way. Not in all cases. We ask for international transfer authorizations, but at the end of the day, this would be the easiest way.
Well, to complete the picture, we have chosen the BCRs. We have approved BCRs since beginning of 2012, and we are on the constant process of implementing them. This is unfortunately not a process you start and you finish one day. It's an ongoing process, but we found it to be very helpful to improve overall data protection and privacy management. And so our BCRs are also our core data privacy policy. The main policy we have, despite sector-specific or product-specific policies, which are then subject below that core privacy policy.
Jennifer, want to make a...
Yeah, I just want to add one comment. I didn't want to imply by what I said that with all these efforts, that means we can transfer data anywhere, because we have very clear prohibitions, either in regulation or in law, to say, for instance, financial services data that's originated in the United States cannot leave the United States, and that's regulatory requirements for that sector. We have other situations where the client says, no, I don't want my data processed in somewhere like China for whatever reason. So we have to manage those around the company in terms of either certain processes or not, don't allow transfer from one country, certain country to another, or in some instances for certain clients, we have to restrict transfers that we might be doing for other clients.
Okay, thank you. We prepared some questions in advance, which I think you'll find relevant. And the first question is, why appoint a data protection officer when, for those countries where it's not a legal requirement? What are the advantages and disadvantages? And Delphine has some thoughts on that.
Yeah, well, as you know, we have a legal obligation, and that's great, because for EU institution there is no competitive advantage, of course, to appoint a DPO. And in general, this obligation of having a DPO is really positive to ensure compliance. It's positive, but it's not sufficient. I will explain why later. I can just give you two concrete examples of the general positive effect of having a DPO in office. First, when the EDPS was established in 2004, 12 big EU institutions had already appointed a DPO. And these 12 apostles had clearly launched the compliance process, whereas other EU bodies had no clue of what data protection was about. And then, in a few cases where institutions had not replaced the DPO in due time, the compliance mechanism was blocked during the absence of the DPO. In our day-to-day work, having a DPO in place is a key factor to ensure smooth cooperation between the institution and DDPS. And the DPOs are the privileged interface between their institution and DDPS. The fact that they are part of the institution, that there is this idea of proximity, puts the DPO in an ideal situation to ensure compliance from the inside, to advise and intervene at an early stage. They are local and they know business and processes better than we do. So the law is good, but the law is only the end of the beginning in the way towards compliance. Concrete measures must also be put in place to ensure that the function is efficient. And Leticia, Cecilia and Philippe mentioned it before. DPO must be allocated enough resources to carry out their duties, enough time, enough staff. They must have access to specific training. Their independence must be ensured, so they should report to the top management and not to their direct superior. They must have a sufficiently senior position in the organization. They cannot be confronted to authority problems. They must be involved, and you said it also, from the outset in the decision-making process where necessary, so as to ensure privacy by or in design. And they must be visible to be reachable, so in the the organigram, in the intranet, in meetings, everywhere. But the most important thing is, we think, is to have the support and the commitment of the top management. Compliance is not only a question of law, but also of political, organizational will. And one could think that the appointment of a DPO is the end of the compliance process, where, as I said, we think that it's only the beginning.
Okay, thank you. Jennifer, have you got any couple of quick comments? I think your organization with your business is all about personal data. I think there's probably no choice. But,
no, internally for our company, there really isn't a choice. But I think I would classify the private sector into three groups. Very small companies, which in some jurisdictions may be exempt from the law because they're so small and maybe they don't handle sensitive data. Companies that simply want to be compliant and a good citizen. And then companies that want, are very worried about their reputation and want to say, I go beyond what's mere, baseline compliance. And obviously a company like ours, it's very much of a competitive requirement, I would say, not just an advantage, but a requirement that we go beyond the law, and so we have lots of audits from clients. But I think that the first thing that the management has to decide is, where do they want to be? Do they want to be compliant, or do they really want to build this into the way they manage their reputation? And then that drives what follows from that.
Right. Okay. Quick.
When we were studying within CEDPO the role of the DPOs and how different it was in the different member states, we came to the conclusion that it was not only a question of a column of advantages which is greater than the column of disadvantages. And actually the cost thing which comes sometimes into the discussion, I have never seen this in a chief financial officer. And actually this is something necessary even if the law does not impose it. So when you decide that the DPO is necessary, it's because there is a complexity in the rules that nobody else would be able to guide the organization in order to know what is the right thing to do. You need to have also conscious that you have an exposure, as Jennifer mentions. Sometimes it is not only a question of the sanctions, which will become an issue with the draft regulation within Europe, but even in the countries where the sanctions are not that important, the consumer trust is something which is much more important sometimes. And this is something also that the DPO has a role to play within the organization, not alone, but within the organization. So the only disadvantage I can see is for the DPO, actually, to have the role that he or she is intended to play. We have some papers, in particular with respect to incentives, that we have prepared for the appointment of DPOs, when we have seen that the discussion was no longer whether it is mandatory or not, and maybe it would not be mandatory, but whether the organization needs to understand or needs to be incentivized that it is not only in order to avoid the sanction, it is not only to avoid the notification, because in certain countries, not to make a notification to the Data Protection Authority is actually not very, is not an incentive strong enough. In Spain it is so easy. Even if we are strict in other things, the notification thing is maybe the easier thing in the law. So the fact that this is the only thing that we gain because we appoint a DPO, this is not sufficient. And there is a lack in the regulation from our point of view of incentive, of sufficient incentive for the organizations in order that they see how a DPO may play a very good role within the business and compliance point of view.
Okay, thank you. Well, my next question I'm going to ask only to Gabriela, because Jennifer's really answered the next question already. So Gabriela, so listen carefully. So the question is, are there different privacy policies in your organization in the countries where data subjects do not have rights? And if so, do these differences of policy present you with challenges or problems having different standards in the organization, or do you have one standard across the whole organization regardless of whether there's a privacy law or not?
Of course, the world is complex, and so is this issue. As I just said, we have our BCRs, which is our core data privacy policy. But in that policy, we have an opening clause which simply says and refers to that applicable national legislation has to be taken into account and is not overridden by this policy. So what we try to establish with our BCRs and the core policy is a minimum standard we apply throughout. But despite that, the local laws have to be adhered to. And we also, and I think that's what you probably always need in a group, and not only in the data protection and privacy management area, you have to define a clear hierarchy of policies. So you have to know what is your core policy, and then you might add to this policy country-specific or sector-specific policies where this is appropriate and needed. But you have to have an alignment process for that as well to be sure that there are no inconsistencies between these policies. So it's handleable, but you need this kind of definition and you need a certain kind of discipline to work with that.
Right. So you need intellectual vision, practical skills, and many other cluster of qualifications, quite apart from formal legal qualifications, or not necessarily. Right, any more questions from the audience? Yes, we've got two here. Right, let's go right to the back. And can we have the microphone right at the back, please? You've got the microphone. There's a lady behind you. Right. Could you pass it across, then give your name and your organization? and then put your question.
Thank you. Christos Velasco, Certified Information Privacy Professional Europe, Certified CPO, also in Germany, independent consultant in Mexico. I have a question. How much of your time do you devote to provide training inside of your organization and interacting with the different departments dealing with data? I mean, respective of the data, whether it's sensitive or all different kinds of data, or is this an activity that you mostly outsource to external trainees? Or I would like to hear the views. No, how much of their time does a CPO spend on a monthly basis? Okay,
so what we
making this issue of awareness among the different departments.
Right. So your question is proportion of time devoted to training, and do you do it internally or do you outsource it to others? Let's start with. Well, I think Jennifer actually first.
Okay, I'll go first. On a percentage of time, it's probably 20 to 25%. But what we've tried to do to reduce that, because we've been through a lot of organizational change recently with new leadership and some new products, is we have developed a certification program, which is a 13-module training program, computer-based training program. It's about 9 hours of instruction, and each module has a test. And all of our product and engineering and customer-facing people are required to take it. And so we're in the process of, it was rolled out last year. Most people took it, but you always have the stragglers that you have to catch up and chase down. And so we're in that process of that right now. And that has significantly reduced. We've translated our time from actually doing training to developing training, and then modifying and changing that training as time goes by and changes occur in the business or changes occur in the law. But I think it's a critical component, but we've coupled that because we don't try to train the whole organization. We have about 6,000 employees, and there are about 4,200 of them that are required to take this training. We don't try to train them on all the laws they need to know. We try to train them on what they need to be aware of, and then who to contact and how to exercise our privacy impact assessment process when they are interfacing with something new, so that we can consult with them and sign off on anything that happens.
Right, thank you. We have 1 minute from Philippe, please, on what portion of your time devoted to training.
Okay. Well, I'm not measuring my time on a scientific way. I come to the office in the morning and suddenly I realize that it's time to go home in the evening, like probably most of you. But I would confidently say 20-25% as well, and it's a growing proportion. As I said, I more or less completed phase 1 of the program, which is formal basic compliance, and phase 2 is definitely training, awareness raising. And for example, I invested a lot of time in an e-learning module for members of staff. Part of the training activities are outsourced to professional training institution, but with a very under a close supervision from myself and my team, and I often participate myself to the training sessions they organize.
Right, thank you. I'm not going to ask Delphine because all her organisation are experts, so it's not relevant to most organisations.
Yeah, training is important, and of course it's a challenge in a huge organisation. I would also estimate that the overall time we invest in this area is about 20-25%. However, we use different channels. We use different media, like web-based trainings and other things which are accessible for employees anytime, and without the direct support of a member of the data protection team. We have a mandatory training for our executives, and what we also do, we really develop training concepts. That's one of the core part of our activities, and these concepts involve also using, we call that multipliers. So we design trainings, we train the trainer, and that's how we really manage to get through this huge organization. You cannot do it personally, neither myself nor my team members, so that's very obvious.
Right, thank you. Right, we've got about 2 minutes left, which leaves 15 seconds each. I'm going to ask the panel One question. Yeah, I know, but I don't think we're going to finish on time. We have to finish on time, I guess. So come and see the panel at the end. The question is that it is often said that getting privacy right provides the organisation with a competitive advantage, and all that. So we can all that as a theoretical nice idea. But do you think that actually has resonance, and do you think your top management really thinks that? And we'll start with you, as you have to leave very promptly.
Thank you very much. Well, the classical answer is it depends. You cannot give a throughout answer for probably an entire company. It depends very much on the sector. My personal experience is that it is a strong competitive advantage in the e-commerce sector and online services world, really. There you can see that the privacy and data protection seals are increasingly developing, and I think they are very important for, well, customer retention or customer gaining. And in this area, the data protection officer really has to also develop his or her skills to support the business with the guidance needed in such a certification process. And I can only say that in this area it's also absolutely undisputed by management that this is a competitive advantage.
Right, thank you so much. Leticia?
Well, I think in my sector, it is not a competitive advantage because everybody dealing with health-related data needs to comply. Is a must-have. I mean, you cannot make a difference from your competitors because they are not compliant and you're compliant. That's a very difficult thing to do. Everybody needs to comply because we're dealing with health-related data, minors data, and so it is not seen as a competitive advantage, but as a must-have in the company. You need to comply. It is a basic for the company. So this is the way top management understands data protection.
So it's part of the business culture?
Yeah.
Right, okay, thank you. And last word to Jennifer, because you don't have nobody's in competition with the European Commission.
Yeah, I mentioned earlier, it's an absolute must for a service company or a vendor, particularly one that's handling a lot of information, sometimes sensitive information for your clients. And so while it's certainly, we pride our program on being better than the competition, we couldn't do our business without one.
Right. Okay, thank you. Well, that's a good note to finish. Unfortunately, no, you have to finish, don't you? Because I'm merely moderating. But we could. Sorry about the people who want.
I would like to leave the opportunity to this person to pose the question, and then we close. As a chair, I will then use my authority in order that you are able to pose your question. It is difficult to hear you without the microphone.
Okay, my name is Miguel Recio. I'm a Spanish data protection lawyer and a student of a master in data protection. Just so quickly, for example, in France, the Data Protection Authority has a lot of power, I will say, about the DPO. He can, or they can even remove a DPO or recommend the removal of a DPO. What do you think for the rest of the countries? Should the rest of the countries follow that or not? The relationship between the DPA and DPO. Thank you.
I will provide now my personal opinion and not necessarily as a representative of any of the roles that I may have. I think it is a very bad idea that the DPA has this task. For the DPO, it is not, I would say, an agent of the DPA within an organization, or at least is my view of the role that the DPO must play within an organization. The DPO is helping, is not the responsible for taking all the business decisions within the company. It plays a role, or she plays a role within providing some particular aspect in order that the decision is well-based with respect to the different aspects that may be implied, and among others, data protection. So that I think that the organization should be the one that should take the decision as to whether the data protection officer has been able to play the role that he or she is expected within the organization. And that's why he or she must be close to the management, because otherwise he will not even have this little independency that it is necessary. You are never independent in your life, in general, when you are an employee or even when you are a services provider. But at least when you are in the top, you may have some more influence or margin of maneuver in order to at least provide your criteria and to base it in order that others with you are taking a decision.
Yes, for your information, in the EU institutions, it's the other way around. An institution cannot dismiss or remove a DPO without the agreement of the EDPS. So that's why I have extremely good relations with the EDPS.
Yes. Do you want to close? We may close the session. We thank you very much for all your participation, and I hope that it has been of your interest. In case you want to be close to CEDPO because you are DPOs, there is a flyer in your bag just in case you want to contact CEDPO as an institution or any of the founding and other associations that form part of the Confederation. Thank you very much.